Hello, welcome to Legal Action. My name is David Siegel. I'm joined by my co-host Jesse Barrientos. Good evening. And a special guest today, Corey Bandies. Welcome, gentlemen.
Thank you. Welcome.
On this edition of Legal Action, we are going to talk about child support and the laws related to it and all the necessary issues. Starting with Jesse, since you're so eager to jump on this one, how is child support calculated typically?
Typically, they look at your net income. And so they take things out, deduction for taxes that you pay, Social Security, your pension plan, insurance. Those are the typical kinds of deductions that are allowed to come out of your paycheck to get your net. There's also, there are other calculations, and in fact, they have a program that takes care of those calculations too, because sometimes if somebody is maybe not claiming enough in terms of taking money out, in terms of exemptions, that's going to give them a false sense of how much they're making. It might show on their bottom line that their gross, or their net rather, is lower than it really should be. So you take all those things into consideration, and then it depends upon the amount of, well, you have the statutory guidelines. It depends upon the amount of children that you have. For one child, the statutory guidelines, minimum guideline is 20%. For two, 28, 3, 32, and it goes up from there. But the important thing to look at is, in terms of the calculation, that's just the guideline. Now, the court can deviate from the guideline. They can go either down or they can go up. Sometimes there's a compelling need to go up, but generally child support is intended to take care of the child, to supply his or her needs. And just to give you a situation, if you have somebody who's maybe making $5 million a year gross, or rather net, that's a whole lot of child support. For one child, let's say at 20%, that's a whole lot of money. Now, does that child need all that money to support himself for that year? Probably not. But there's other things that you have to consider. It's for the support of the child, but it's also for the intangible things, or maybe not so intangible, like the roof over their head. So, for the custodial parent, to pay for that, to pay for the mortgage, or to pay for the utilities, to pay for food, all of those kinds of things.
Right.
Well, I was going to interject one other thing.
Sure.
In terms of calculating child support, one interesting thing that is deducted from gross is any previous child support court orders that you happen to be paying. In at least my real world, dealing with the non-millionaires that I deal with every day, the non-millionaires, you have many men, particularly men, who have child support court orders which need to be deducted in order to arrive at the new net income, and then you take typically 20 or 28%, you're dealing with one or two children, as to those children. Though one caveat to that is that if the child that has a child support court order is younger than the ones you're calculating, then you're not supposed to take them. It's not necessarily a pecking order of who races to the courthouse first, as it is the child in terms of birth order.
Yeah, that's right. I recently had a case like that, and we can talk about that a little bit later, where the judge actually held the other way, and it's not which is a whole other issue.
But it's an incentive to race to the court, for the woman to race to the courthouse in order to get the fullest amount of child support possible from the non-deducted paycheck, if you will.
Mm-hmm. Let's refer to men in this example. A lot of men feel that if they have joint custody, that they don't have an obligation to pay child support. Can you elaborate a little bit on joint custody and how child support comes into play?
Well, is that for me or either one? Okay. Well, again, everybody has an obligation, a legal obligation, and even better, a moral obligation to take care of your kids. All right? You had them. They're your responsibility, and you need to take care of them. That's the bottom line. That's what I tell people that come in, and sometimes they don't like to hear it. Okay? Oh, well, I got to pay it. There's no order in effect. No, but you know what? It's your kid. It's your child. You have to take care of them, and that's typically how I counsel my clients. Okay? But even if you have joint custody, now again, I'm assuming when you say joint custody, it's not shared residential custody. That is to say that there's just one person is the custodial parent, and they're able to share the day-to-day decision-making process.
Correct.
So, yeah, I mean, that person has to pay child support. You're both obligated to support the child. And those intangibles that we were talking about earlier in terms of the roof over your head and all these other things, the food and all that stuff, you know, the person who has custody of the child, too, the physical possession, is also obligated to support. And obviously it flows from the person who doesn't have the non-custodial to the custodial, but they're also obligated to pay or to support the child.
The reason that exists is that even within a joint custody agreement, you have typically one residential parent.
Right.
So the residential parent is presumably spending his or her own money on the children living in his or her own household. You need the money flowing from the non-residential parent to the residential parent, just as it would. It's the same situation as if you're talking about the non-custodial parent
Right.
paying the custodial parent. In essence, there's no difference between non-custodial, custodial versus non-residential to residential within a joint custody scenario.
One of the questions that's often asked in my office is, does the recipient of child support have any duty or obligation to report to the payor as to where that money is being spent, how it's being spent? Do they have to account in any way, shape, or form? Corey?
No. One word answer is no. This has been tested at a trial level, and the judges have consistently said no. What it is the custodial parent or the residential parent, as the case may be, gets the money into their hands, they spend it as they believe to be appropriate, and it's just deemed to be appropriate, unless you could prove to some very high level that there's some true abuse. If the custodial parent were, for example, a drug abuser, an alcoholic, I suppose there may be some mechanism for accounting. But in a standard situation, the answer is simply no.
What about in a case of neglect where the children are obviously not being fed, not being cleaned, not being clothed properly? Would that be a case where somebody can come in and say, hey, where is the child support money going?
I suppose the answer is yes, but I think it also naturally would be coupled with a petition for change of custody,
Absolutely.
which would be the reason that you'd be wanting to not only account for the money as it's being spent, but want the children within your household so that the abusive situation is simply squelched.
Okay. Jesse, you talked about the standard percentages that the court guidelines that the court uses for amount of child support, but how long does one have a duty to pay child support?
Until the minor children or child is emancipated, and that covers a bunch of things. For example, when the child is 18, sometimes a little older, it depends, some people turn, they're still 19 when they're in high school, so when they get out of high school, when, for example, they're in the armed services, stops. Upon the death of the child, if that happens, before that time.
Sure.
And so when they're emancipated, that's when it'll stop. We were talking a little bit earlier in terms of a situation, for example, a handicapped child, where that's a special needs, and it would turn to a special needs adult, where that support may continue because of the needs of that individual.
But there's some special rules on that, too. It doesn't necessarily follow.
What are some of the special rules?
Well, the special rules are when a child is over 18, has completed the high school era, but is a special needs now young adult, it doesn't follow the strict guidelines of the child support scenario of 20%, 28%, etc. Then you delve into the actual cost needs of the child, the financial resources the child may have, because there may be some money coming in for whatever reason. Social Security disability, for example, may be coming into that child's household. The resources of what has heretofore been the custodial parent, and the financial resources of the former non-custodial parent.
And that's very similar. We're probably jumping ahead, but it's very similar to contribution for college expenses.
Very similar, yes.
Okay, so there's an obligation to pay child support until the child's emancipated. Correct. And now you're telling me that there's possibly an obligation to contribute towards college expenses? Explain this.
That's right. I mean, there are factors that are enunciated in the statute, and it basically says if the child has an aptitude for college. There's some other things that parties can agree to in terms of, so the child may want to go to Harvard or to Yale, but parents don't have the financing to support that, so the child doesn't have, or the young adult at this point, I guess, wouldn't have the choice to say, hey, I'm going here. But it's interesting that the children of divorced parents can force the parents to pay for college, whereas the children of parents who aren't divorced or are still together they can't make them pay for college. That's absolutely right.
Now, Corey, isn't it true though the child has to first exhaust loan applications and see if there's other means to pay for college before they look towards the parents?
Generally, yeah. I mean, they certainly have to apply for loans, scholarships, grants to the best of their ability to offset the cost of both the parents
Right.
and their own income.
And correct me if I'm wrong, Jesse, it's not just the income of the parties at that time, but the complete financial package in terms of assets and expenses and everything.
Right, of everybody too. And nowadays, it didn't really used to be like this, but nowadays they expect the child to contribute to his or her education. And so, if that means even in some instances working a part-time job, and then it also depends. I mean, you might have a disparity, and many times you do, of income between the father and the mother, and so the contributions are going to be divvied up that way. Who is best able to bear that burden? And it is a burden.
Another point,
sure.
as a tangent to something Jesse was saying about child possibly going to Harvard, for example, I've heard many judges, though this is not statutory law, this is a matter of decision-making kind of law, that they'll take the costs at the university, since we're talking about an Illinois situation, that the cost of University of Illinois and split them as such, even if the child should happen to be going to Harvard, Yale, something, so that it limits the amount of cost the parents have to pay, putting a further burden on the child, him or herself, if they're going to go to some very, very expensive school.
But
Have you ever had a case like that?
I haven't, but I think that the bottom line, and that's a good way to work that, but the bottom line is, you know what, if your son or daughter has the opportunity and the aptitude and is accepted into college, you know what, do whatever you can, all right, which means you should start saving now.
Right.
That's a fantastic thought, but that's not
what happens. True enough.
The two of you have jumped way ahead to college. Let's take this all the way back to the point where the child is just growing up. And child support is very important for non-collegiate things like food, clothing, shelter, extracurricular activities. A well-crafted judgment is going to have terms which will mandate that a payor, the person paying the child support, submit to the recipient their income for the year, whether it be W-2s, annual tax returns, things like that, correct?
And some people are going to resist that because one party doesn't want the other party to know what they're making. However, it's good in a way because it kind of discourages, in some instances, that petition, and it encourages because if the income is the same or less, the payee is not going to do anything. The payor might if it's less money. If it's more money, then you can bet that the other person, that the payee, is going to come back in on a petition to increase child support.
Well, this is leading to my next question. How much of an increase in income would warrant a person bringing a motion to increase child support?
There is no specific answer to that question, at least not in my experience. But typically, there needs to, first of all, the law says there has to be a substantial change in circumstances. So if you're talking about the custodial parent asking for an increase in child support, there has to be a substantial change in the payor's financial circumstances.
So would a standard of living increase, would that constitute a substantial change in income?
Well, no. What I was about to say was typically the payor has to have at least, I'd say, a 15 to 20% increase in income. I shouldn't say pay, of income from all sources above that which was established at the time of the order. So, and typically, I always tell people it's 2 or 3 years. Less than 2 or 3 years, most judges won't consider increases.
Is that what you found to be the case in DuPage County?
Well, it really depends. If it's a difference of $5 a month in terms of an increase, that's something I'm not going to bring because I think it's a waste of time. If it's going to be a difference of a couple $100, then because if you look over time, 12 months times $200, especially for people that need the money. Again, it's child support, and it just really depends upon the particular situation because sometimes the children, as they grow older, their needs change. They have other activities that they're involved in, perhaps, maybe tutoring and that those kinds of things, and they just change. Kids are expensive.
Sure. Corey, what are the ways that child support can be paid?
Well, it can be paid either directly from the payor to the payee, or more typically through what's called the State Disbursement Unit, known as the SDU, which is certainly encouraged. It's encouraged that the payor have an automatic withholding from their pay, assuming that they're a W-2 wage earner, and that it be sent to the State Disbursement Unit, who in turn does an accounting, make sure that everything is being received properly, and then issues a check in its own treasury, if you will, to the payee, typically the mother.
Okay.
And that's an inbred, if you will, accounting system that if typically the mother is going to claim that there's an underpayment of support, well, you can get what's called an account adjustment review, an AAR, from the SDU or sometimes the Department of Public Aid as to exactly what was paid and what was not paid.
That also seems to alleviate the issue of the woman, in this case, asking the ex for the child support. Where is it? Why are you late with it? You didn't give me the right amount, that kind of thing.
That's true. But let me tell all you folks out there, okay, that guess what? You know what? Keep your receipts, because it's very important. And as good as a job that they try to do, all right, you know, they're going to miss some of those things. And so if you're organized even just a little bit, maybe you have a spreadsheet, or maybe you just make copies of the checks that you have and put them in a file, because when that time comes, you'll be able to establish with little effort exactly what you paid, because you have copies of your checks in order to show that.
Let's talk about a case where someone does have an order for support.
Right.
It's being paid through an order of withholding. Let's talk about the father in this case, the father of the child. If he loses his job, so there is no child support forthcoming, how would you go about enforcing that child support order? Beginning with you, Corey.
Well, okay, what? In order
He's not
to,
paying.
Okay, but he's not paying, and the mother is looking to enforce the order.
Correct.
In that kind of case, what you have to do is do what's called a petition for rule to show cause, because he's not paying, saying that he's being willful and wanton in his not paying. Typically, though, if I can go up on that answer a little bit more, the man will typically bring a petition to abate or reduce support if, in fact, his income is less or non-existent, so as to not have to deal with a petition for rule to show cause. He's actively saying, I should not be held in contempt of court because I've had this drastic reduction or complete termination of income.
I have found a lot of men, though, won't take that proactive approach and come into court and get the order changed, and they just assume that because they're not working or they're unemployed, that the mother is not going to push them on the child support. It's a big mistake.
Yeah, nothing could be further from the truth on that, because each obligation of support is a separate judgment.
Correct.
And it doesn't even matter if you have an agreement with the payee, okay, that says, oh, don't worry about it, I understand you're not working. Does not matter. Okay, it's a separate judgment, and you're going to be on the hook for that. So the very first thing.
Court order saying that you no longer owe X number of dollars per week, whatever. Otherwise, it just keeps on ticking. The amount just keeps on growing.
One issue that I could bring up, it comes up all the time, is the issue of visitation juxtaposed to child support. Are these two issues remotely related whatsoever? Jesse?
No, they're separate.
Why is this often confused?
Well, in every judgment that I've seen, every judgment that I write, it says specifically that the allowances for support are different than visitation rights. And if somebody does not pay child support, that doesn't mean that you withhold visitation. And likewise, if somebody's withholding visitation, that doesn't mean that you stop paying child support. Okay, again, people think about it, and this is the difficulty, because they don't. It's the best interest of your child. And so, hey, I still have an obligation to continue to support you. If I don't get to see you and the other person is withholding, me seeing my child, okay, you're still going to need support. You're still going to need all those things that you would need any other way. And the remedy for that is to go to court in the same vehicle as a rule to show cause for that, why that person violated the order by not allowing you to see and exercise your visitation. And then on the other side, hey, if somebody's not doing what they should do and not allowing that, hey, I'm not going to pay support. No, because guess what? You're going to be in violation of an order. And that will be willful, because especially if you had the ability and the funds to pay that and you stop paying that. And a lot of judges, again, depends on the judge, but a lot of judges will not take kindly to that.
And also, of course, there's a criminal statute as to the issue of preventing visitation, assuming that there's a court order that has a specific visitation schedule. And I don't think anyone wants to get involved in the criminal court system.
That's true. And I find, too, and just if you don't mind, just kind of going off of that a little bit, I find, essentially, it's a citation for the first couple, and then after the first two convictions, then it gets kicked up a little bit. I find that I've heard from some of my clients that, the police aren't willing to really enforce that, and aren't really willing to do that. And that's a shame. Again, I don't know, each individual situation is, on its own merits, dependent upon that. But if they won't enforce it, then it doesn't have any teeth.
Right. Well, let's get back to the situation where the gentleman is brought before the court, and what you've mentioned is a rule to show cause why he should be or not held in contempt.
Yep.
And he,
It's interesting, it's posed as a
Right.
negative, why he should not be held in contempt.
Right.
And for him, he has what's called the burden to prove why he should not be held in contempt, not for the woman to say why he should be held in contempt.
okay, let's say he submits to the court, he explains to the court that he cannot find employment. What will the court likely do in that case?
If he can't find employment?
Right,
Okay,
and he has been
well,
unable to find employment.
okay, well, first, at least in Cook County, what they'll do is take some preliminary steps in making him maintain what's called a job diary,
So-
and report back to court with some frequency as to his attempts at finding work.
Right.
How involved is that?
Well, it's a matter of looking through newspapers, looking at the internet, trying to find some job that's suitable to your background, to your skills. And typically a judge will make you maintain either 3, 5 odd lookings per, per
Like unemployment certifications.
Something.
Can he take a lesser paying job to try and avoid paying the statutory child support that he was ordered to pay?
Well, if he finds a job in good faith, which happens to be less income than he was previously making, the court certainly would consider a reasonable reduction in child support because of his reasonable attempts at finding work at all.
Okay.
That's
So
my
good faith
experience.
then is the key there as to whether he's,
That's correct, your
Absolutely.
intention.
Oh, absolutely.
okay. What is your opinion on that?
Well, with respect to somebody taking a lesser pay, again, good faith is important, but to take a lesser paying job, I mean, there'd have to be a pretty good reason. I mean, one good reason I think would be health. Some jobs are high stress, but a lot of judges, again, each judge, you can have 5 judges and they'll give 5 different
So
opinions
your
and 5
question
different
presumes that
decisions.
he was terminated from a job.
My question presumed that he was acting in bad faith.
Bad faith.
And that he was not seeking employment, and then when he was brought before the judge, he said, you know what, I'm going to get a job,
Right,
but I'm not going to get a job that I'm capable of doing.
Yeah, then it's a different-
answer.
sure.
If it's bad faith, the judges will not allow a reduction.
And in DuPage, you do the same too in terms of making a job. And actually, when you say with some frequency, I've seen them make them come every week to report. And it's not going to be good enough that I went here and there. What they want to see is they want to see where you went, what time you went, who you spoke to, and why you didn't get the job, whether or not you got an interview, why you didn't. And they want to see some phone numbers. So it has to be fairly detailed.
That is the typical
Yep.
job diary in Cook County also. That's true. That's true.
Does child support cover, this is for you, Corey,
Okay.
does it cover daycare expenses and extracurricular activities such as dance, music, lessons,
No,
sports?
those are on top of child support. Child support is for the support of the child or children themselves. The daycare is separate, and yes, the custodial and non-custodial parents can both be made to pay into daycare on top of child support, and that's true too of extracurricular activities through the end of 12th grade.
Yeah, once again, the reason why I ask this question is a lot of clients have a hard time understanding why they're ordered to pay child support, and then there's a separate order for them to pay daycare or a portion of daycare, extracurricular expenses, a portion of the medical coverage for the child. In other words, a lot of men feel overwhelmed with the amount of support that they have to pay beyond the statutory amount that you first talked about, Jesse. How do they handle that when they can't survive on their own with what's left out of their check?
The short answer is too bad. Okay, I mean, basically, it is what it is, and that's what you have to pay, because you took an active part in creating a child and bringing a life into this world, and you are going to be responsible for taking care of that child. Because when you're not, what happens? People go on public aid, and that burden is shared amongst all of us. And if there's nothing wrong with you, and if you can work, okay, then that's exactly what you should do to support your child. And so, I mean, a lot of people don't want to hear that, but that's what it is. Is it difficult? Is it bad? Is it unfair? It may be, but that's the way it is.
I really have nothing to add to that. He's right.
What about a situation, Corey, where the recipient is earning more than the payor? Does the payor still have to pay the statutory child support guideline?
The answer typically is yes, but again, it will be per guidelines of their own income. If it's a huge disparity, I mean, if you're talking about the custodial parent making literally millions of dollars compared to the non-custodial maybe making even less than $20,000, $30,000 a year, there have been situations where the judges have actually said to the non-custodial parent that you can pay a lesser than guidelines or even no child support. But again, let me repeat, that requires a huge disparity in income.
And just to kind of add to that too, when there's a deviation from the guidelines, and again, those can go either up or down, that's a good reason to do it, to deviate on the downward position. But there are other types of situations, for example, when you're completing the divorce. There may be an asset, there may be a marital real estate, a home. And so perhaps what happens is the husband or the wife decide that, hey, listen, you know what, I'm going to let you have the equity in that. And then so as sort of a consideration for doing that, okay, the child support would be, the guidelines would be reduced, and that would be laid out because it's required that be laid out in the order, the reason for that, or maybe even reserved or abated for a certain amount of time. The difficulty sometimes with that is you don't know what somebody's going to make in the future. If we're dealing with one child, 20%, or two children, 28%, then, dependent upon my job and my ability to earn income, that might be a whole lot greater.
That's exactly why child support is always modifiable. It is never set in stone.
Right.
If certain situations exist, you can always go back to court to ask for reductions or increases, or as the case may be.
Corey, is it hard to enforce an out-of-state child support order in this state?
Well, the answer is you have to enroll the child support court order in this state, and then it becomes a court order of this state, and then you can enforce it from there. In and of itself, you can't enforce it at all because it's not in our system. So the answer is you have to get it into our system.
And is that a difficult process?
Well, it's a process involving paperwork that lawyers know how to do, and it's enrolling a foreign. It's called a foreign judgment. Foreign means different state. It doesn't necessarily mean a foreign country. Some people are a little confused by the word foreign. And once you've got it into the system, you then have to serve the person who's in the other state, the state of origin, and they will become subject to what's called jurisdiction, meaning the power of the court to rule here in Illinois.
Jesse, does child support have a termination date in the order?
It does, and it's when the last child is emancipated or turned 18. I mean, those other emancipation events, you really don't have much of a control over. But when the last child is, and it has the kind of, I guess you could call it a step down in terms of percentage, that is allowable these days to be able to kind of reduce that. But, when you're talking 18 years from now, the income of the payor is going to be different anyway. So what that's going to do, either one or the other, one person, either he's going to come in, even though he doesn't have to come in that situation to reduce it, but maybe he's making less money. He's going to want to come in to reduce it that much more. Or the custodial parent is going to want to say, okay, well, now I just lost, this much from this child because this child is emancipated, and then so what am I going to do? He's making more, so I'm going to come in for the remaining child or children to get an increase in that.
I've had a few clients in which, typically men, who have asked, they want to reduce the child support because the child is now 18, but their income is risen to a level that by decreasing the percentage, it might actually end up in an increase in dollar amount. So I've, in talking to these kinds of clients, I've said, you know what, it's worth it doing absolutely nothing because you're actually subjecting yourself to an increase when your intention was a decrease.
Exactly. And I think that's something that's kind of very closely related to that, and I don't know if we were going to get into that or not, but the dependency exemption. I think they kind of go hand in hand sometimes. And generally, I don't know, Corey, what do you think, that most of the time what's fair is that one person has them in odd years, the other person has them in even years, right?
Right.
But I think that sometimes what happens is that if one person is paying a great amount of child support, that person generally will get the exemption for that time.
Thank you, Jesse. Great information. Thank you, Corey. Thank you, Jesse. Thanks for joining us on Legal Action. We'll see you next time. Take care.